What a mess. There's over 300,000 asylum claims. Your government, that will likely take 25 years to process the backlog. Your government has spent almost over $2 billion on things like hotel rooms for bogus asylum claimants. Bogus asylum claimants are getting resources that Canadians aren't eligible for, and here we are today. Minister, the Canadian Bar Association, Refugee Lab, Amnesty International, and other legal advocacy groups have argued that the immigration provisions found in Bill C-12 are unconstitutional. Several of them have said that they are preparing for challenges, that there could be over 24,000 court challenges. Have you, Minister, directed your officials to begin preparing to defend the provisions of this bill in court in advance of these challenges?
So thank you very much, Member, for that question. There's two parts to it. The first, you're talking about asylum. So our government is committed to rebuilding Canadians' trust in Canada's immigration system.
Thank you.
Making our borders stronger.
Question, and Chair, I realize but I asked a pointed question, so I expect a pointed response. Have you directed your officials to begin preparing for legal challenges to defend those in court? You're asking us to support this bill. It is highly likely to be challenged in the courts. Have you directed your officials to begin preparing legal defenses?
So thank you for the question. Again, the intent of the ineligibility measures are to protect the integrity and the efficiency of the in-Canada asylum system against sudden increases.
Thank you. So I'll take that as a no. With your word salad, which is just really unfortunate because you are asking us to support this bill, which virtually every legal association in the country has said is unconstitutional, and you're word salading us on whether or not you have directed your officials to begin preparing it. So would you say that it is fair to characterize, given that what you've just said, that this is an attempt by the Liberal government to punt the mess of the asylum system to the courts?
So again, I don't know what salad you're speaking of, but the courts have confirmed that neither the Charter nor the Refugee Convention require a particular form of refugee determination process. In this legislation, we have the PROS system, the pre-removal risk disorder, the pre-removal order, and so the government's position is that these provisions are consistent with both the Charter and with the Canada's international refugee law obligations.
So I'll just ask one of your officials, is, in the ministry's opinion, is the asylum deadline contained in Bill C-12 Charter compliant? Anybody? No?
Can I get a clarification, Madam Chair, the deadline?
Deadline? What
Correct.
deadline?
So it's the deadline by which that somebody has to apply. I think that there's an arbitrary timeline. Is that Charter compliant?
So again, our assessment based on the bill being tabled is the provisions are consistent.
Thank you. Okay. So these provisions are going to be appealed. Minister, you haven't directed your officials to begin preparing to defend these appeals, so it's highly likely that many people will perceive the measures in this bill as a way to just punt, the government is punting this to the courts. Have you consulted with your provincial colleagues and come up with a cost estimate of the legal costs it will, cost provincial governments in terms of bogus asylum claims challenging the provisions in this bill?
Well, again, Charter challenges would go through the federal court system, and that is the
Yeah, but there are
responsibility of the federal government, and I've got the
Yes, but
justice officials here.
Who pays for the legal aid, Minister?
That is the responsibility of the federal government.
But there's also provincial support that happens as well, too, right? And that's what you haven't done. You haven't gone to provincial governments, as you guys hashtag welcome to Canada, 300,000 plus bogus asylum claimants across the border from the U.S. I digress. A recent news story involved over 200 similar stories where applications for asylum were used. They used copy and paste language, and they all shared a similar immigration consultant. Why doesn't Bill C-12 contain provisions to require asylum claimants to state their reasons for claiming asylum orally on the record upon arriving into Canada to prevent this type of fraud?
Look, excellent. Look, these are excellent. That's exactly why we're here today, to study these provisions. These are to protect us against fraud.
Yes,
and about fraudulent claims.
So that's not in the bill. Why isn't it in the bill?
The approach targets fraud in individual applications as well as a coordinated fraud scheme to prevent systemic abuse
Okay.
within the immigration and citizenship programs, and does hold actors
So I don't think
accountable.
that's
One
not in
minute.
the bill. Shouldn't asylum claimants have to prove that they made their claim in a timely manner instead of making the government do so? And why didn't you include that provision in Bill C-12?
So there are clear provisions in this act
But
in
not that
terms of the
provision.
ineligibility rules.
Not
The
that
1-year
provision.
deadline and the 14-day.
But those are likely to be punched at the courts, and some simple switches, which could have prevented people from abusing the asylum system, you chose not to include, which is interesting. Minister, have you done any sort of studies on the totality of costs of bogus asylum claimants with regard to benefits across the across jurisdictions over the last 6 years?
I
response.
just recently met with the the provincial territorial, and we actually discussed, that was part of the discussion that we also talked about it. We talked about the
What was it?
federal
What was
support.
the total cost?
I'm sorry, that's time. You're going to have to continue this in the next round, Ms. Rempel Garner.